Hi, good morning. So today let's talk about forcefully removing a shareholder from a company. Okay? And I'm not talking about removing a director. Remember, a director is an official of the company, but a shareholder is an owner of the company. Shares are basically property, and property rights are protected under Article 40 of the Constitution. So how then do you remove someone forcefully who is a shareholder from that company? Okay, I'm sure you found yourself in a situation where you have one of your shareholders, they're not pulling their weight, they're not attending meetings, they're not working in good faith and for the best interest of the company, they're in breach of the shareholders agreement and their fiduciary duties. Yet when you tell them, just transfer these shares voluntarily to me or to someone else in the company, they don't want to do that. So basically, they are the Solomonic woman. You know, remember the Solomon story where the woman was saying, kata tu mtoto katikati, chukue half na half. They are okay with the company sinking, you know, because they have nothing to lose. Whilst in the company, there are shareholders who really mean business. They want the company to thrive, and they're putting everything they need to put. This other one is a joyrider, but yet they are owners of the business. So how do you deal with that situation? So I know most people know the procedure of removing of a director. And I know because we deal with small companies, most directors are director shareholder. But you have to make a distinction. A director is an official of the company, a shareholder is an owner. So removing a shareholder, the stakes are a lot higher. So let's start with how you remove a director. Removing of a director is very simple. You issue them with a special notice. Special notice requires that you give them 28 days notice. Notify the company. The company will notify members of the company. Members will have 21 clear days to attend the general meeting. They come to the general meeting. In the notice, you notify the director that at the general meeting, you'll be looking to remove them. They can put in their representations, defend themselves. When they come to the general meeting, you hear the representations, and then you reduce it into an ordinary resolution. You file it, you remove the director, you file the notice of cessation in the companies, and boom, you've removed them as director. But is it possible to remove someone as a shareholder of a company? The answer is yes, but it depends. Yes, as a default, the only straightforward route you can remove a shareholder from a company is if you go to court under unfair prejudice and say that this director is operating in an oppressive manner, you know, is not operating the best interest of the company, is in breach, is, you know, conflict of interest, and then the court can make that order and order that their shares be transferred to someone else or be bought out by someone else. So that's the only surest way of doing it. The other route, which I feel is an easier and cheaper way to do it, but most of us do not go down that route because of how we place a lot of over-reliance on BRS and eCitizen, is a couple of other ways I'll discuss. But it is anchored on the Articles of Association. So the only other way you can remove a shareholder is if you deal with their shares. If that shareholder no longer, in a lawful way, has shares in the company. How do you do this? Either they transfer their shares voluntarily, or if the Articles of Association provide for a mechanism in which there'll be a compulsory transfer of shares. Okay? But what do we do most times when we're incorporating a company? You just go and tick the model Articles of Association. Now, the model Articles of Association, don't get me wrong, are really progressive, but they fail to cater for specific eventualities such as this. And that's why you might find that when you are now looking to remove a shareholder, ukiangalia model articles, it doesn't provide it. So the other way in which you can do it is amend the model articles of association, include compulsory transfer of shares, have a clause there that says if a member does X, for instance, is in breach of the shareholders agreement, then they must transfer their shares. Once you amend your Articles of Association, I'll share the procedure of amending your Articles of Association and new filing with the registry. Then if a shareholder is problematic, you can invoke that section. The other route is still through having it in the articles of association that the company will buy back the shares. The company itself will buy back the shares. So there'll be special resolution, there'll be valuation of the shares, and then the company can buy back the shares. The other route, which again is anchored on the articles of association, and the model articles of association does not have, is forfeiture of shares. So usually shares are either paid up or unpaid. But if you ticked the model articles, you'll find out that the shares are assumed to be fully paid. But if you amend your articles of association, then there's some legal room there. So the forfeiture of shares works in this way. You write to the shareholder and tell them you have unpaid shareholding. At the point of subscribing to the shares, you did not pay up full capital. So you give them notice, then they're supposed to have paid the shares within that stipulated notice. And if they don't pay the shares, then the company can have them back and they're removed from the company. But you see, all these other ways of removing a shareholder who's an owner of a company from the company must be anchored in the articles of association. So if you went to the model articles of association and you'd want to amend, that is the only route that can accommodate removing a shareholder forcefully. Otherwise, the only other route is now going to court, suing them, and then court making that determination. If you have any issues to do with company-related transactions, whether it is you want to expand capital, you want to remove a director, you want to remove a shareholder, you want to appoint another director, you want to restructure anything company, I'll be happy to have that conversation with you.